Today's guest knows all the lawyer jokes, and in fact, he's been known to tell more than a few of them himself. Corey Furman is the owner of Furman IP here in Regina, and they focus on intellectual property law. So if you've ever wondered whether what you're thinking or building can be covered, he's the guy you need to talk to. Corey, welcome. Thank you for being here.
Well, thanks. Well, thanks for having me. I didn't bring you a good lawyer joke today, but I love a good one, like as much as the next. So just if you're going to tell me a lawyer joke, just make it really hurt.
Excellent. And as a profession, you guys certainly get beat up. So I think that helps to build that thick skin somewhere along the way, right?
Yeah.
So, like, what drew you to law? You've been practicing for how many years now?
I finished law school in 1994, so I feel old saying that because I guess that means about 25 years, something like that, 25, 26 years. Yeah.
And have you always focused on intellectual property?
Since I started my firm. So when you finish law school, is kind of like accounting. You got to do articles first. So I did my articles with the Saskatchewan Justice Department in 94, 95, and then and the economy back then being what it was for lots of people that are watching who were here then knows there weren't a whole pile of jobs around. So I created my own job and decided I'd start an IP firm because it was always something that had interested me, and with nothing better to do and wanting to stick around Saskatchewan because I had met my now wife at the time, not wanting to leave, I thought I'd give it a try. So borrowed a couple $1,000 in an old computer from my dad, and away I went.
And you hear that story so many times, right? Borrowed a few dollars from mom and dad, and back in 94, you could borrow a couple $1,000s. Nowadays, it's a little bit more expensive to get set up. So talk a little bit about the types of businesses that you work with then.
So my practice is in the area of intellectual property law and strategy. So I do patent and trademark and copyright work are sort of what people would more typically kind of equate that to. They're a little simpler words. So I help lots of everyone from individuals through to large companies, protecting patents, trademarks, copyright. I do a little bit of litigation work, although in general, especially with domestic and local clients in Saskatchewan, we're not a litigious bunch. We all seem to get along. So that's not so bad. So a lot of the clients that I work with, like I have it's pretty cool because I get to work with lots of different companies of different sizes in different industries. And I mean, another interesting thing about, another piece to that is not only helping people to sort of figure out and file and protect their patents and things like that, but also, I mean, the most interesting part of it to me is sort of just helping clients to figure out the rest of their IP strategy, including their export strategy. Like I love doing international work. So I help people who are exporting to kind of match up their IP footprint in other markets, whether those are other markets elsewhere in Canada or outside Canada, sort of help them to match up the timing and the footprint of their IP portfolio in the US or in Europe or wherever as they go along. So I got to meet a ton of interesting people in those 25 years or whatever, both from clients to lawyers in other countries and stuff like that. It's pretty cool.
So is it primarily product work, or even from a tech perspective? If I want to develop a piece of technology, and let's say an app, but I want people around the world to use it, is that considered exporting, or how does that work?
So when I started in the 90s and for the first 10 or 15 years, and it could have in part been just the nature of the people I had in my team at the time, we did a lot of work on agricultural implements, oil and gas inventions, stuff like more mechanical type inventions. I always have had a bit of an interest in software kind of stuff. I found it in my old Commodore 64 in the garage the other day, which I won't let my wife throw out because I'm a nerd. And
you got to try and turn it on. Like, what can you do with it?
I haven't tried to turn it on, but so I always had a bit of interest in software. Literally, probably in the last 6 or 8 years, over half of my patent practice would probably be with software companies. So helping people to protect different, and whether it's sort of online things or offline, it's a lot of the innovation in the province these days is being done in those areas. I still get to do lots of interesting work with some of the same older sort of client relationship, like ag manufacturers, oil and gas companies, those kinds of things, but lots more software now. So like I say, which has probably just kind of been, I kind of have fell into a niche that I enjoy.
Right.
And one of the things I love about my business, I kind of work on my own and get to do what I want, and work with people and companies I like. So
yes, and that's one of the benefits that people don't often talk about being a small business owner. You get to be direct essentially every day. And if you get too picky, then margins get a little slim. And if you get a little too generous, well, then you're dealing with clients that you don't want to work with. And so, yeah, there's a lot of freedom that comes with picking your clients, knowing the work you want to do, right? It's something that I've really come to value. So I just want to touch on this software thing because I know that there's a booming market here in Saskatchewan, app developers, software developers, things like that. So that's tough to copyright because whether it's a website or it's an app, it's not hard to get to the code anymore. So how do developers protect themselves?
Well, there's a few interesting issues in the context of software protection. So you first, one of the background issues you even have to deal with is it does impact how you protect it, is even whether you're using open source or proprietary development tools. So because if you are, as lots of people are now, developing in whole or at least in part on some open source platform, then if your eventual plan is to monopolize your idea or your technology by patenting it or something, that factors in. You can still do it most of the time, but you got to it's just something you got to be careful about. With software, there's really, you can patent, software is patentable in certain circumstances where it's actually achieving a novel result. So if it's basically capturing and transforming data to yield a new commercial function. That sounds kind of wishy-washy in terms of an answer, but it's gotten a little more difficult in the last 3 or 4 years, at least, to actually patent software in the U.S. because the definition that's being applied in the USPTO is a little different than it was before. It's being applied. They haven't changed the rules really, but they're applying them a little differently. But so patents are there as a tool to kind of try to protect the actual functionality, and then there's copyright in the code. In the interface. And the copyright is oftentimes how you would protect the code itself. Lots of times clients would contemplate doing both. Sometimes lots of times, even whether it's software or even in some other industry, lots of clients who are being maybe a little more aggressive or serious about protecting themselves from an IP perspective might try that multi-pronged approach of, you'd also be able to protect the brand that you use on it. So, you have a trademark there or something, but the primary way that you would protect the core of a software development would be with patents and copyright. And then the other way you can protect yourself against certain parties, and one of the questions oftentimes clients have to ask themselves in terms of IP protection strategies, what are you trying to protect yourself against, or who are you trying to protect yourself from?
Right.
So whether that's I'm trying to protect myself from my customer not paying their license fees anymore, I'm trying to protect myself from my competitor ripping me off. I'm trying to protect myself from the developer going across the street and taking the crown jewels with them. They're all different approaches, and so one of the other pieces with software is that in addition to patents and copyright, we still try to rely pretty heavily on contract too. So you can actually, even where there's not otherwise an IP right that exists, you can kind of create some inter partes rights by agreeing to to whatever. So lots of times what clients will want to do in the software space is, and particularly in the gig economy now, where there's lots of people working on contract, like if they're not employees, because if you're an employee coder, there's a statutory presumption that your employer owns your work. But if you're, and those vary a little bit from country to country, but there is, generally speaking, an understanding that if you're being paid by your employer to develop, then the fruits of your labor will be owned by the employer. But contractors, for example, or even small businesses procuring development services from, like, if you go out and just get some guy to gig it up and develop something for you, one of the things you probably want to contract with somebody on is you want to contract in respect of ownership of the copyright, ownership of the IP and the software, and you frankly ideally want the developer to agree that what's created is yours. Honestly, one of the issues you're going to run into is the developer's not going to want to agree to that. Now, there's lots of times there's fair ways to deal with that, because you can actually say, look, I mean, because lots of times what developers want to do, they're just like lawyers with our looking up in our computer system our precedents and reusing them. The developers want to reuse they want to reuse, libraries, code snippets, whatever, for some different purpose. I mean, they're not even necessarily going to go and they're not even necessarily going to go and copy and resell your dog haircutting scheduling app to somebody else who's going to compete with you in dog haircuts.
Right.
But there might be some little bit of the programming that they did that could be useful in another project someday, where they're developing a scheduling app for use by a massage therapist or something like that. And frankly, you probably don't care. And that's probably the thing that primarily the developer would be concerned about. So I think that lots of times the way we address that is to say, look, the customer, I'm purchasing the development service and the software from you, and I want to own it, but I'm prepared to agree in a way that you can feel free to, in a non-competitive way, reuse whatever you want.
Exactly.
And then that's lots of times, there's a middle ground there that usually works.
So one of the conversations that I'm seeing primarily coming out of the US, I primarily work in that creative industry, and I don't know too many small business or local businesses who have trademarked their brand and their name. So most of the folks that tune into the show are either friends and family of one of you and I, or small business owners. So what is typically what you're seeing? Like, I don't want to say advise, because I know that puts on a legal hat, but should a small business owner be thinking about trademarking their brand, trademarking their name? Is that an arduous process? How do you usually approach something like that?
I mean, the short answer to whether it's an advisable thing to do is, I think it is. I mean, effectively, to register a trademark, and whether that's your sort of key house brand, product names you're using, whatever, something, if it's a brand, even a logo, different kinds of non-conventional trademarks, source identifiers that you use to your benefit to identify your product or service to the public. I think registering your trademarks is effectively cheap insurance. I mean, it's because the person who is the first user is really the person who's entitled to the registration. So lots of times we will, I typically tell people, if it's a reasonably straightforward Canadian trademark registration, cost-wise, you might spend $1,500, $2,000, something like that, start to finish, to get a registration done. And at the end of the day, if that sort of crystallizes your place in line, I would say it's cheap insurance to somebody else coming along and creating a headache behind you somewhere. It's not a particularly arduous process from a client perspective in particular. I mean, for example, like in my firm, I consider it my job to make it as easy and painless for my clients as possible. You tell me what to do, pay my bill, and I'll leave you alone. and
Exactly.
I'll come and tell you when it's done.
Yes. Yes,
And
exactly.
well, actually, I'll come and tell you before it's done, because one of the current problems in the Canadian context is the Canadian Trademark Office. It's embarrassing. It's taking 3+ years to register a trademark in Canada right now.
Get out. Okay, so
So-
if somebody started the process though, so you would never even know that trademark had started. Somebody else could start the process as well. How in the heck does that work?
Well, so what happens typically, the way you keep on top of that is when you would be, actually, I would argue that it's maybe even too late when you've got to the point of, okay, you've already started using it and you want to just file it. But at some point when you're picking a brand or picking a trademark, it's a good idea to do a search. Because if we do a search, we can search for business names, previously filed applications, which would come up. I mean, they'll come up within a couple of weeks of being filed in a search. But there were some changes made to the Canadian Trademarks Act a couple of years ago that effectively we now, in a very simple way, have pretty much a first to file system. So filing date is very important.
Okay.
So we kind of set it and forget it. I mean, we'll stay on top of it every 6-8 months and see what's happening with it. But I mean, it's literally currently it's taking pretty much 2.5 years from the time we file for the trademark office to get to the point they look at the file. Frankly, once it gets onto somebody's desk, it moves pretty quick. It's maybe another 6-8 months and it's done, but they're way behind. And in fact, we can go and file. I had a client here not so long ago where we filed in 6 other countries, and the 6 other countries, we were done the registrations in all of the other countries before we had even heard anything from the Canadian Trademark Office. It's awful, to be honest, because trying to explain this, because a big part of my practice is also doing Canadian work for foreign companies. So I help foreign companies who are protecting their marks or their patents or whatever in Canada. And it's embarrassing to have to explain this on behalf of the Canadian Trademarks Office that, well, look, we can do our best, but it's going to take this long. So suffice it to say, it takes a long time. I think it's a good idea to get your stick in the ground, and then once you file, and or even regardless of if you file, if somebody copies you and or is infringing your rights, you can still basically seek to enforce on a common law unregistered basis. It's better to do it with a registration, just because the evidentiary burden flips, and it's a lot easier for the trademark owner than it is for the potential infringer. But so that's probably me rambling on there, but certainly I think it's a good idea to do it, in part because of how long it's going to take to come out the other end, and when you do want to get to the point that you can, and that's another reason why actually when you're picking brands or trademarks, it's also a good idea to do a search, because honestly, it's going to take 2-3 years to come out the other end of the sausage maker. What you probably want or pretty much need is, like when we do a search, we'll write an opinion that says, and I mean, we're responsible for the accuracy of our opinion, that says, look, we think that you can or can't get this registered based on what the current state of the register is. And so, because you can't sit and wait for 3 years to launch your business.
Exactly.
And you shouldn't have to. But particularly if for a client who's looking at doing licensing or franchising, if you're looking to franchise, things like that, your potential franchisee, one of the things when they get to the point of due diligence with the franchise lawyers, one of the things they're going to say is, basically under the franchise agreement, the value we're getting from this arrangement is by and large access to the brand. What can you tell us about, is the brand protected or protectable? So at that point, if you can flip it out on the desk and say, look, according to the lawyers, it is. Hopefully you're not going to flip it out on the desk and say, oh, we asked for an opinion and they said no way, but I still want your money. But yeah, so I think that searching and clearance work like that becomes even more important given the timing and the delay. And just frankly, before, whether you're a small business or a large business, you don't want to pile in and spend a bunch of time and resources on developing any equity in a brand that's walking on somebody else's rights and that you're sooner or later going to have to step back from.
Mm-hmm. So what's interesting to me about that is I remember when I registered my business, I remember searching the Canadian database for a business name. And in fact, I couldn't have my first choice because there was a Canadian registration. So in the end, I registered a second alternative and, sort of picked from, whatever the choices were. And then here in Saskatchewan, as long as you meet ISC's, benchmark and you actually describe the business, then they could care less. But then you watch what happens. Businesses go and promote themselves under whatever public brand they want. So, that whole area of branding and trademark and what belongs to who, and that would be very interesting, I imagine, from a search perspective as you start to get into some of that.
Well, and certainly, there's different sort of degrees of searching we would do. Everything from a quick and dirty search of the trademark database just to tell you, look, this looks like a good idea or a bad idea to even search anymore. So we can give an opinion on registrability based on what's in the trademark register. So whatever somebody's filed as a trademark before, in the Canadian context, the Canadian Trademark Office, at least right now, they don't search for business names and those kinds of things. All they search is trademarks. So it's a narrower data set. But if we do a more comprehensive search, which is the other kind of a search that we most often do, we search trademark register to give an opinion on registrability, and then we do an adoption opinion, effectively. Like, can we see, is there anything latent that we think you're going to infringe somebody in the marketplace, even if they don't have a registration? And what that searches is business names, publications, websites, domain names.
That's very broad.
All that kind of crap that's out there, because there I'm getting into my real legal terminology now, all that kind of crap that's out there. But all those added sources of unregistered uses, because a prior user still has some rights, which you can find in a worst case scenario. You could have something that's registrable, but there could still be some, mom and pop shop in some corner of the country somewhere that has been using something confusingly similar in the same kind of a business. And you roll into town and want to set up 3 franchise outlets, and all of a sudden there's a problem, because somebody else is effectively in front of you in terms of an unregistered common law use. So different set of data. That's typically the level of assurance, like clients that are looking to franchise, for example, or expand. That's typically the level of assurance I would suggest to them that they probably want, because particularly given the time that it's taking right now, you need as much certainty as possible before you're going to jump in and spend the money, right?
Oh, exactly. Yeah, exactly. Corey, it's funny. One of the things that I really enjoy about doing this podcast is when I get business owners talking about what they love and what they do and who they are, it makes the time evaporate. And in some cases, like literally, I will ask 2, maybe 3 questions, and the entire time period disappears. Right. And so, I'm watching you talk, and of course I'm watching the clock, which we have like 1 minute left.
Oh, excellent. So, yes. I've never been accused of not being able to talk, Barb.
Exactly. Yes, exactly. So on that note then, Corey, wrap us up. Like, tell us, when should we be calling you, and where do we find you online? Give us your little spiel.
Yeah, well, and certainly if companies are either looking to proactively just sort of even do an audit to see what they have for IP assets, or kind of figure out what, if anything, might apply to their business, or if they find they have questions specifically about trademarks, patents. Honestly, even if you just have a sense you have some IP that's worth protecting and you don't know what it is, I'm happy to try to give you a hand and help you out with that. You're able to certainly reach out to our firm by phone in Regina here. We have clients all over Saskatchewan and Canada and around the world. Probably the easiest way to start is just to punch up our website, which is just furmanip.com. We're in the process of getting a little chatbot finished on there that will kind of maybe help you to figure out if you have some real basic questions, maybe might try to help you figure out, well, I think I have a trade secret question versus a patent question or something like that. But we're happy to hear from you and sort of answer any questions that way. That's probably and then social media wise, you can look me up on LinkedIn and connect there or whatever, but probably the easiest way to start is just to kind of jump on our website and have a look there, and then reach out to my office from there, and somebody in the team will be happy to help. I love just getting to talk to people about their businesses and their ideas, and my dad used to tease me about this, that I was the only lawyer that he knew of that liked a good field trip, but I still make house calls. So there's nothing I love more than getting out on the factory floor. So so I'm happy to talk to people about things anytime and just sort of help them try to get pointed in the right direction. So have a look at our website. Like I say, there's a reasonable amount of information in there. We're just a new site, so we're just kind of trying to get it's interesting because if people have questions, we're trying to get some more information on there to kind of address what people's usual questions would be. And then from there, I'm happy to have a chat anytime.
Okay, that sounds awesome. Well, thank you very much for joining me today, Corey. I really appreciate just even a little bit of insight around, trademark and that local business or, any kind of intellectual property that someone's working on. So hopefully the phone will ring a few times for you after today. And if anyone else would like to be a guest, they can email me at barb@googlegirl.ca or reach out on Facebook and Instagram at Above the Fold CA. Just a reminder, you can even submit questions in advance of our show on our Facebook page. I'm your host, Barb McGrath, local business owner and Google Girl. Remember, you worked hard for your success. Don't keep it a secret. Bye for now.